Good morning, everyone, and thank you for joining us again for our Beasley Allen webinar series. Today, we're going to be taking a deep dive into the latest trends in mass tort litigation. That's going to include acetaminophen, social media, Ozempic, Kratom, and hair relaxer litigations. So my partners, Ryan Duplechin, Aigner Kolom, and Clinton Richardson are going to discuss all of the intricate legal, medical, and societal implications of these cases. They're going to try to also give you valuable tips to help you and your firm protect your clients' important legal rights. So while we're waiting on the last of our registrants to join us this morning, let's take just a few moments and meet our three speakers. First, my friend and partner Ryan Duplechin is a leader in Beasley Allen's Mass Tort section. Since joining the firm, Ryan has litigated cases involving joint replacement devices, dietary supplements, and pharmaceutical drugs like Xarelto and Belviq. Ryan was recently appointed to serve on the plaintiff's steering committee for the nationwide GLP-1 MDL, a truly high honor and something that's going to occupy, I know, a lot of his time in the coming years. In addition, Ryan serves as the vice president of the Alabama State Bar Young Lawyers section, and he's a member of the State Bar's Leadership Forum. In addition, Ryan has served as lead attorney in oral arguments before a number of federal and state courts throughout the country. He's authored numerous legal publications and briefs, all of which have been critical to the success of our clients' cases. Ryan is a huge asset to Beasley Allen, and we are so happy to have him with us today. Next, Aigner Kolom also serves as an attorney and principal in Beasley Allen's Mass Tort section. During her time with the firm, Aigner has been involved in numerous national cases to include the Xarelto, bone cement, PPI, opioid, hair relaxer, and hip replacement litigations. Aigner has been selected to the Mid-South Super Lawyers Rising Star list ever since 2020, and she's also been named to the National Black Lawyers Top 40 Under 40 list. I've had the opportunity to work personally with Aigner, and I can tell you, she is a tireless advocate for our clients, and she's a tremendous contributor to the success of the Mass Tort section here at Beasley Allen. Finally, my partner, Clinton Richardson, there's another key member of Beasley Allen's Mass Tort section. Over the past several years, Clinton has actively worked on the Juul litigation. He received his undergraduate degree from the University of Alabama and his Juris Doctor from Faulkner University. Before joining Beasley Allen, Clinton litigated matters in the areas of employment discrimination, federal criminal defense, and Section 1983 litigation. He also worked for the United States Attorney's Office in the Northern District of Alabama, where he prosecuted False Claims Act cases, defended claims premised on the Federal Tort Claims Act, and responded to numerous habeas petitions. Clinton is and has been a true asset to our firm, and I'm delighted to have him join us today, along with the rest of our panel. So before I turn the program over to our speakers, I need to take just a moment to go over some housekeeping notes. First, today's webinar has been approved by the Alabama and Georgia State Bars for 1 hour of CLE credit. In order to receive full credit for attending today's session, you've got to stay on for the duration of the program. A link to today's presentation was included in the Zoom confirmation email you should have received when you registered, but by the end of this week, you're going to get another email with a certificate of attendance and an updated presentation, set of slides, that is, and video link. You can email your completed evaluation form to webinars@beasleyallen.com. This webinar is being recorded, and for those Alabama and Georgia attorneys participating by phone, please remember to email us your name, phone number, and state bar ID number. You can send that also to webinars@beasleyallen.com. That's going to help us ensure you receive full CLE credit. Also, be sure to check out the events page of our website at beasleyallen.com/events, as we're going to be adding more webinars throughout the year. Finally, if you've got questions during today's webinar, I want to encourage you to use the Q&A feature located at the bottom of your screen. We're going to set aside time at the end of today's program to try and tackle all of the questions submitted by our viewers. So with that, Ryan, Aigner, and Clinton, let's get started.
Thank you, David. We're going to start with Ozempic, the GLP-1 litigation. And just to tell you, I mean, we're going to take an overview over several litigations today. I could talk about just this one that I'm involved with for the entire time, but we've got to cover some ground with some other ones. But Ozempic, I mean, we've all heard the jingle way too many times. It's all over TV, and it has, I mean, millions and millions of views on TikTok, Instagram, etc. Ozempic, I mean, this drug, this word, I mean, it's taken the whole world by storm. And right now, I mean, we're approaching 5 million people that are on GLP-1s, like Ozempic, and we'll talk about some of those other ones a bit later. The main manufacturers are Novo Nordisk and Eli Lilly. They do separate GLP-1s. GLP-1s is kind of the short version of it. And there's lots of scientific words like I don't know, the whole wording of GLP-1, but we're going to try to narrow things down and keep it simple today. Um, but I mean, this popularity of Ozempic, I mean, it is we've only heard about it in the last few years, but it's not by accident. It's been a a strategy, a plan for a very long time before we even heard of it a couple of years ago. And to give you a sense, I mean, it started with back in, let's say, 2010 area. Each of these GLP-1 manufacturers, I mean, they realized that this was coming down the pipeline, this kind of medication that could have profound effects on weight loss. And they started campaigns to really change what people and the medical community thought of when they thought of obesity. And they wanted medical providers to start seeing obesity as a disease. And that was all part of the plan for when their drug that you have to take for, I mean, they don't tell you this, but I mean, to keep off the weight, you're supposed to take it for the rest of your life. And this medication right now is about $1,300 a month, and they're failing to warn people about a lot. But one of them is that, I mean, when they go off it, most people um, gain all the weight back. And so back to this change in how we see things. And so in 2013, the it's the American the so the AMA was determining whether so the American Medical Association was determining whether to recognize obesity as a disease. And there was a New York Times kind of, I won't say investigation, but an article into it afterwards, where at that AMA convention, they had a separate committee that looked at whether they should recognize obesity as a disease, and they said no. And then they opened it up for the entire organization to vote on it. And the American Association of Clinical Endocrinologists was really behind the effort to drum up these votes and get these votes to recognize obesity as a disease. And if you dig into it a little more, behind the American Association of Clinical Endocrinologists, it's a mouthful, but the gold level corporate sponsors, the highest level sponsors, is none other than Novo Nordisk and Eli Lilly, who down the road, I mean, now it's estimated that GLP-1s are making in the ballpark of $15 billion per year already. And I mean, to put that in context, I mean, we've handled other MDLs litigations where the drug was on the market for much more years than this, and the entire drug over the entirety of it being on the market would made in the realm of 25 billion, which of course is a huge number. And I mean, GLP-1s are almost at that, they're over that within 2 years. And so it's just really a I mean, a huge shift in the way that these drugs have entered the market, and even there's been, I mean, investors, Wall Street are all over it. This is Novo Nordisk and Eli Lilly have been tremendously um, well-performing stocks because of these drugs, and there's been investors, and they've told these financial folks that they expect about 9% of everyone to be on these drugs by 2030, and that is around 30 million people. And so there are profound effects, and we'll get into kind of what these are a little bit more. Just wanted to set the stage there, but we can go to the next slide. So Novo Nordisk and Eli Lilly, they're the two main manufacturers. Novo Nordisk came out with Ozempic first, and so that is when you hear of semaglutide, that is there all these underlying drugs have very long names like that, and then they end up coming up with shorter ones like Ozempic, Wegovy, etc. But that is their version of the GLP-1 agonist. And then Lilly, they came out with Mounjaro first, and then Zepbound. And so kind of the differences in these is that Ozempic and Rybelsus, actually no, Ozempic and Wegovy, those are both injections, and Rybelsus is a pill, and Ozempic is approved for type 2 diabetes, and Wegovy is actually approved for FDA approved for weight loss. And that Wegovy just has a bit more dosage in there versus Ozempic. And then Mounjaro on the Eli Lilly side is approved like Ozempic for type 2 diabetes. And then they just got Zepbound approved in November 2023. So that one's fairly new. But essentially, so like I said, there's scientific ways to explain all this, and I could try to make myself sound really smart, but let's try to boil it down. So these medications, they affect both the gut and the brain. And so in let's start, I guess, the brain first. When we all know when we eat a meal and we start to feel like we're full, and then that will last probably for 20 minutes or so after we're done eating, and then it kind of goes away. So that is mimicking GLP, and that's kind of what the drug does. But instead of just being 20 minutes after you eat and that feeling of fullness, it is hours and hours, days, etc., that you're feeling full, and you look at some food and it just looks like there's no way I'm eating that. I'm already full. I mean, it would be like going to a buffet and then someone wants to take you to a second buffet. You'd be like, no way, I'll just sit here. I'm not eating more. And that's kind of how they feel always, essentially. And then in the gut, it slows down it slows down food processing. So if you see your stomach is a processing food, kind of like, I kind of think of it as, I mean, definitely different, but kind of think of it like your sink with the food disposal. But it slows down that process greatly, and so it slows down the so it really does keep food in your stomach quite a bit longer. And we'll talk about some of the injuries that we're seeing as well. We can go to the next slide for now. So this is the GLP-1 litigation, and so the first case was filed in August 2023, and then there were several others filed, and then we, another firm, but we in general as the plaintiffs petitioned the Judicial Panel on Multi-District Litigation to create an MDL, and it was the MDL is currently in the Eastern District of Pennsylvania, in Philadelphia before Judge Prater. kind of the first steps in any MDL is to first appoint the plaintiff's leadership, and then also to get an initial case management order in place that really sets the tone for how the and some initial considerations in the MDL and how the case is going to proceed. But we just got our initial leadership appointment, and as David mentioned, I was fortunate to be included on that group. And then next we'll have what we call Science Day. It's coming up next month, and essentially Science Day is an opportunity to present, I guess, an objective kind of educational picture of the current science and medical literature to the judge, and so she can have that initial foundational knowledge when she's going forward and ruling on certain things. We can go to the next slide now. So these are the injuries that we're currently looking at. I'm not going to go through and read each one of them. So gastroparesis and ileus bowel obstruction are the most common. Essentially, gastroparesis is the kind of the weakening of the walls of the stomach, and then when it's supposed to be passed, I guess, to the intestinal to your intestines, the ileus bowel obstruction is more obstruction of once it gets to the intestines part of it. Like I said, trying to stay very, very high level. For those of you that do medical malpractice, this is important. Surgical aspiration cases. So we think about GLP-1s, and it keeps food in your stomach. And these manufacturers have really failed to warn doctors and surgeons that people should be off of Ozempic, these GLP-1s, for a really extended amount of time before they go into surgery, so they don't aspirate, which is an extremely, as many of you know, extremely dangerous. That can happen in surgery. But if you do med mal, those might come in your office, and many people wouldn't know to connect those. But please check to see if they were on GLP-1s, or even before you have medical records. You can send it to us, and we'd be glad to order those records for you and check out on our end. But we can go to the next slide here. So we're the next litigation already. So this one should be a bit shorter, but this is the acetaminophen autism ADHD litigation. This is dealing with women who took acetaminophen ordinarily during pregnancy, and then their child ended up developing either autism or ADHD. This litigation has been going on for a bit longer than the Ozempic litigation, since 2002 or so. Clint, we can go to the next slide. So yeah, this is kind of the overview of litigation. These are some of the high points that we have. And so initially, early on, in our Mass Tort section, we deal with lots of drug device cases, and acetaminophen, like Tylenol, is not FDA approved. It's regulated by the FDA, but not in the same way as drug and devices. And so there was some very unique, novel preemption arguments that essentially would say, hey, we have to comply with federal FDA law, and your state law products liability claims are telling us to do something that conflicts. And so we cannot do both. And so this whole litigation should be thrown out. That's preemption in a nutshell. And we were able to overcome that hurdle pretty early. The judge was very concerned about what the FDA thought of this issue. You can have different views on that as far as separation of powers and whether judges should be doing that. But so they essentially asked the FDA for their thoughts on what this kind of label should say as far as warning mothers, families, doctors, etc. and the FDA essentially said that they do not plan to get involved in litigation like this, and so they declined to answer. But so the other big highlight is that the judge separated discovery into two phases, and phase one was about science and general causation, and so whether acetaminophen, prenatal use of acetaminophen can cause autism, ADHD. And so we did significant discovery with that, and then did Daubert briefing, and that initial Daubert briefing did not go in our favor. The judge ended up cutting all the general causation experts, and then actually after that, there was new plaintiffs that filed cases, and they proposed a new expert that had not been a part of that initial Daubert ruling. And then so that was considered, and it's currently on appeal right now. And so we'll see if that comes back down and if that litigation continues. But we'll see what the Court of Appeals does. We can go to the next slide. And so these are products and injuries. At first, when you get into a new mass tort, you tend to be a little more broad because you don't want to narrow things too quickly, so to speak. But since we've kind of seen what we have and where this litigation may be going, this is the very simplified products and injuries that we're looking at. The mother regularly used acetaminophen during pregnancy, so this is more than just taking it once. It would be taking it regularly for back pains, etc. And then the child was diagnosed with autism or ADHD. We can go to the next slide here. So yeah, these are general acetaminophen products: Tylenol, general acetaminophen, and then paracetamol is what they call it in Europe. And I don't expect us to have any clients in Europe, but you could see it in the US. We'll see. But we can go to the next slide here. Okay, so we're moving along. Kratom is another relatively new litigation. So Kratom, we can go to the next slide. So Kratom essentially, I know we have people from all over the place on this webinar, but if you're in Alabama and you've never heard of Kratom, that is understandable because it is illegal in Alabama. In our case, our initial cases came from Atlanta, Georgia, and now we handle them quite all over the place. But we'll talk about which states it's legal in. But in states like Georgia and places where it's legal, it is either a pill form that you may see like in the front of gas stations and stuff, along with some other I don't know, different kinds of supplements, et cetera, up there at the front, maybe in smoke shops, et cetera. And then it also comes in something, it's called an extract that looks kind of like a 5-hour energy bottle. And essentially Kratom came from plants overseas, Indonesia type area, and then it comes over here. It's processed. I don't want to go through the entire manufacturing process, but it is eventually extracted, et cetera, and put into either these powders or pills. And one thing that it has is that the Kratom industry is really trying to take advantage of the opioid epidemic. They've really marketed these to people that may be struggling with that, and they're essentially telling people that this is an organic alternative to opioids, and it can give you the same type of high, but it's safe, etc. There has been medical literature that has connected it to seizures, deaths. The DEA, FDA have looked at it, decided not to make it illegal quite yet. I mean, just like quite a other things, that there's a lot of different science out there. But this stuff is definitely something to look out for. We can go to the next slide. So these are kind of the states that have, so the ones in red, those are the ones who've expressly said that Kratom is illegal and that it's not allowed to be sold in their state. The ones that do not have anything are the ones that have not said anything, and so Kratom is presumptively still able to be sold in those states because it's not quite it's still very new. I mean, it's not quite under the purview. It's kind of disputed actually whether it is a dietary supplement under the FDA's purview, but different state governments have taken their opportunities to rule and create law on it. So Georgia has a check mark, Arizona, Utah, Nevada as well, and there's like a I don't know, like a Kratom Safety Act. And so those states have initiated this act that says kind of some quality control type rules and says that that you need to warn consumers about side effects, et cetera, et cetera. And so Kratom is currently, I guess, expressly legal in those states. We can go to the next slide. So the Kratom litigation in general, so it's interesting. I'll try not to get into all the details, but the Kratom litigation actually came out of one of these Kratom companies. Well, initially, just like most of these litigations, we kind of notice a trend in medical literature. There was studies that started connecting it to seizures, deaths, overdose, that kind of thing. And we started looking into it, and there was a case in federal court that we could pull all the documents where one of these Kratom companies was trying to buy another one, and those negotiations went south, and one of them filed an affidavit with all the other ones, text messages, emails, all kind of stuff that became publicly available. And we started digging into this and kind of realizing that that there may be some I don't know, definitely some liability here about knowing about this stuff and really I don't know, creating all kind of entities, hiding things, places, using faulty addresses and all kind of stuff. And it's been quite the the challenge to try to piece all that together. And then the bottom right, recently the Tampa Bay Times did an investigative article on Kratom industry. There's 3 parts to it. I encourage you, if you're interested in Kratom in general, to go check out those Tampa Bay Times articles. They really do a deep dive into the story behind Kratom and some of the negative effects that we've been seeing. But that is a challenging litigation that there's no MDL or anything at this point. We're litigating those in various state courts, mainly in Atlanta right now. But it'll be interesting to see how that one progresses. And we can go to the next one. Yeah, so these are some of the products and injuries that we're looking at. So like I mentioned earlier, I mean, this litigation is fairly new, and so it's broad and it could be narrowed. But these are some of the injuries that we're looking at. Some of our filed case right now relates to a horrific seizure that ended up leading to a permanent brain injury. Client was in the hospital for several months. It's a terrible scenario, and hopefully we'll be able to put all these puzzle pieces together and hopefully help her and several others in this litigation and hopefully help some of your clients as well. But that's all we have. Feel free to contact me or look up that Tampa Bay Times article definitely if you'd like more information. But I appreciate your time today.
Thank you, Ryan. Welcome to the Beasley Allen Social Media Litigation Update. During this portion of today's webinar, I will provide background information on the history of social media, discuss what led Beasley Allen to sue the 5 largest social media companies, and address where things currently stand in this litigation. Note that while much of this discussion focuses on Facebook and Instagram, this litigation effort also addresses wrongful conduct by YouTube, TikTok, and Snapchat. For clarity, note that as of October 2021, Facebook and Instagram are collectively referred to as Meta platforms. Social media really came into existence in the early 2000s. Depending on your age, some of you may remember MySpace, which was the first social media platform to reach 1 million active users. Believe it or not, at one point, MySpace was more popular than Google. Today, a quarter of teens report using social media almost constantly, and the average person uses social media 2 hours and 27 minutes each day. Facebook has grown exponentially over the last 10 years. It had 100 million users in 2008. In 2021, it had 2.9 billion active users. As you all know, Facebook and Instagram don't charge you to create an account. They make most of their money from allowing companies to advertise on their platforms. In 2019, Facebook made $69.7 billion from advertising. In 2021, its ad revenue was $115 billion. Simply put, the more time users spend on the platforms, the more companies want to buy advertising. Stated differently, the more time users spend on Facebook and Instagram, the more money Facebook and Instagram make. For evidence of this, consider that it is widely believed that Meta's executive bonuses are tied to how many hours per day each of you lose while scrolling through their platforms. In 2017, Facebook noticed that users were not liking and sharing content as much as they had in past years. User interaction was decreasing, which meant Facebook's value as an advertising tool for companies was decreasing. Facebook was becoming less valuable. Facebook decided it had to quickly change or it would lose billions of dollars. In September 2021, the Wall Street Journal began to run a series of publications based on internal Facebook documents. At that time, the source of the documents was unknown to the public. The documents show that, since at least 2019, Facebook has known that prolonged use of the platform causes mental and physical harm to teens, often in ways only Facebook fully understands. Facebook's own documents show that prolonged use of the Meta platforms makes body image issues worse for 33% of teenage girls, that 13% of those with suicidal thoughts attribute those thoughts to use of the platforms, and that 17% say using Facebook makes eating disorders worse. Knowing this, Facebook still developed plans to market to preteens and actively contemplated whether there's a way Facebook could engage with younger children during play dates. During an October 3rd, 2021 episode of 60 Minutes, Frances Haugen, a former Facebook employee, was revealed as the source of the Wall Street Journal's information. 2 days later, on October 5th, 2021, she testified before Congress regarding her experience and observations as a Facebook employee. She explained that, to counteract the 2017 user decline, Facebook made substantial changes to its platform to increase the amount of time users spend on the platform. Prior to 2018, Facebook's newsfeed was organized chronologically to show the newest posts at the top of the page. In 2018, it implemented changes to amplify content that Facebook determined is the most reactive, because Facebook concluded that the reactive content would draw the most attention and therefore make Facebook the most money. Reactivity was measured by what Facebook calls meaningful social interaction, or MSI. One Facebook executive said, "Our algorithms exploit the human brain's attraction to divisiveness. If left unchecked, Facebook would feed users more and more divisive content in an effort to gain user attention and increase time on the platform." The 2018 change centers on negative content and works to overwhelm users with this content as soon as they log on to the platforms. Maybe most concerning, Haugen detailed Facebook's failure to warn the public of the dangers of the platforms, despite knowing that the parents of today's children largely lack the skills needed to advise children on how to safely interact with social media, because these parents did not engage with social media when they were children. The overwhelming majority of documents within the public domain that detail the beginning of what has grown to be a social media epidemic were released by Frances Haugen. Facebook has long known that teenagers lack the ability to self-regulate, and that this lack of impulse control renders many teens powerless to restrain themselves from continuous, often unhealthy interaction with the platforms. But keeping in line with the common theme across all of defendants' platforms, safety was discarded in favor of financial gain. As previewed earlier, the prolonged problematic use of social media extends to YouTube, TikTok, and Snapchat, as 95% of children ages 13 to 17 use YouTube, 67% use TikTok, and 59% use Snapchat. TikTok itself has classified more than a third of its 49 million daily users in the United States as being 14 years old or younger. Teenagers who use social media platforms are likely to use them consistently. One study estimates that 62% of children ages 13 to 18 use social media every day. An increasing number of younger children also use social media daily, with 18% of children ages 8 to 12 reporting using social media at least once a day. Daily use for many teenagers does not merely consist of logging onto a platform just once. Rather, many teenage users check social media repeatedly throughout the day. Even more alarming, some teenagers never stop looking at social media. As this chart shows, nearly 20% of teens use YouTube almost constantly. TikTok and Snapchat are close behind, with near constant use rates among teens at 16% and 15% respectively. Meanwhile, 10% of teens use Instagram almost constantly. To date, Beasley Allen has filed over 300 personal injury lawsuits in federal court and California state court against Facebook and Instagram, TikTok, Snapchat, and YouTube. Our personal injury filings allege theories of product liability, negligence, fraud, and unjust enrichment. We are prepared to represent clients across the nation and plan to file many more lawsuits soon. Very early on, Beasley Allen centers his efforts on Facebook and Instagram. Once again, this is because a key whistleblower, Frances Haugen, is a former Facebook employee. The documents that she provided to various media outlets were obtained during her time with Facebook. We later expanded our focus to include as defendants Snapchat, TikTok, and YouTube because of apparent similarities in how the platforms function. Our litigation criteria includes people that started using social media before age 21, that use the platforms for more than 3 hours per day, and that believe they were harmed in either of several ways because of their social media usage. Given our case criteria, many of our clients are currently minors according to the law of the states in which they currently live. As many of you know, the court requires the selection of individual guardians ad litem, or GALs, to represent the best interests of our minor plaintiffs. The court has approved ex parte applications for GAL appointment. Applications submitted by parents or guardians are usually approved and finalized shortly after submission. Applications submitted by those who are not parents or legal guardians will be taken under consideration by the court. One of the key harms at issue in this litigation is social media addiction. In general, social media addiction is characterized as being overly concerned about social media, driven by an uncontrollable urge to log onto or use social media, and devoting so much time and effort to social media that it impairs other important areas of life. Defendants deny that social media addiction exists, but mental health professionals believe that 10% of all Americans are addicted to social media. The symptoms of social media addiction mimic those of drug addiction. Mood modification and ever-increasing need to use more social media and extreme withdrawal behavior are all signs of unhealthy social media usage. Following up on the concern that social media addiction impairs important aspects of life, problematic social media usage can result in sleep disruption and increased social anxiety, which can lead to a substantial disruption in academic performance. Listed here are the other harms that we are investigating as being caused or exacerbated by social media usage. We prefer that our clients have medical records that reflect diagnosis and treatment for at least one of these injuries, but prior medical attention is not required. If you or someone you know has been harmed by prolonged social media usage, please reach out to us, even if there's been no medical treatment, to discuss how we can help you obtain some relief. Based in part on the large number of lawsuits that have been filed against defendants, on August 1st, 2022, Beasley Allen filed a motion to consolidate federal cases against defendants into a multi-district litigation, or MDL. The federal MDL statute, 28 U.S.C. section 1407, permits the temporary transfer of federal civil lawsuits with one or more common questions of fact to one district court for pretrial proceedings. MDLs promote efficiency. Rather than having hundreds of cases pending before different judges in different courts across the country, MDLs are commonly coordinated in a single courtroom. On October 6, 2022, the JPML issued a transfer order instructing that all social media cases involving defendants' Facebook, Instagram, Snapchat, TikTok, and YouTube be transferred to a MDL in the U.S. District Court for the Northern District of California, Oakland Division, before Judge Yvonne Gonzalez-Rogers. Beasley Allen's Joseph Van Zandt is among the lawyers selected by Judge Gonzalez-Rogers to lead this MDL. Defendants face similar state court consolidated litigation in California. On December 16, 2022, Judge David Cunningham of the Superior Court of California, Los Angeles Civil Division, ordered that California state court cases against these defendants will be consolidated for Judicial Council Coordinated Proceedings, or JCCP. On January 6, 2023, this JCCP was officially assigned to Judge Carolyn Kuhl in Los Angeles. Similar to the MDL, Joseph Van Zandt is a co-lead of this JCCP. Beasley Allen has filed many cases in California State Court and will aggressively litigate for our clients there too. In both federal court and California State Court, defendants tried to dismiss our personal injury cases prior to the start of discovery and were unsuccessful. Discovery is the formal process through which plaintiffs and defendants investigate the facts of the case, and along with the court, scrutinize whether there exist genuine issues of material fact that warrant a trial. In consolidated litigations, efficiency dictates that not every case goes through full discovery. Instead, only those that are selected as bellwethers will be subject to complete discovery. A bellwether case is a tone setter of sorts, being consolidated litigation's method of assessing the strengths and weaknesses of plaintiffs' and defendants' positions on the case, as viewed through the eyes of a jury. A plaintiff-favorable resolution to a bellwether trial commonly instigates settlement discussions amongst defendants. In both federal court and California State Court, we are also litigating on behalf of school districts that serve thousands of children. Each district asserting that their respective ability to perform their duties for our children has been adversely affected by the social media epidemic. One important aspect of litigation that is especially challenging for this group of plaintiffs is our duty to preserve relevant proportional evidence. As we all know, teenagers notoriously lack the ability to control their impulses. Couple that with the fact that defendants have engaged in significant measures to addict children to these platforms, measures that are difficult for many adults to counteract. And what we're finding is that teens are very protective about people accessing their accounts, but also reckless with their recall of account login credentials. Teens are not as organized as most adults, which leads to many forgotten passwords. Forgotten passwords result in being locked out of accounts, which leads to the need to create many different accounts. In addition to needing to create many different accounts because of forgotten passwords, many teens create multiple accounts to avoid parental supervision. A few anecdotes include, we have had teenagers that immediately concluded a call with our ESI personnel, and despite being warned, proceeded to change all their passwords to prevent us from accessing and preserving copies of relevant data. One client professed to having over 100 different social media accounts. Another horrifically attempted to commit suicide after a parent attempted to limit social media usage and access. As I wrap up, here are a few things defendants should have done and still could do to protect our children on social media. Beasley Allen will exhaust every legal avenue to ensure the rights of its clients are vindicated, and the defendants are required to remedy the harm they have caused. Thank you.
Hello, everyone. I am honored to give the update for the chemical hair relaxer litigation. My name is Aigner Kolom, and I am one of the attorneys here at Beasley Allen working on the hair relaxer litigation. We can go to the next slide. Recently, 5 of our clients did an interview for NBC News. It aired last week. If you have some time after the presentation, feel free to go on NBC's website and look at the full interview. But I just wanted to give a quick glimpse of one of our clients so you all can kind of understand just the toll hair relaxer is having on Beasley Allen clients.
I went to the attention of a doctor and learned my situation, that it was endometrial cancer. So,
how did that feel?
it made me feel like my womanhood was taken away, because I don't have children and I couldn't have children. So, you know, to hear that at a young age, you know, when, you know, my family, I come from a family tree where kids, or, you know, you bear kids. I mean, it's no issue. No one had rough pregnancies or any cancer, not in my immediate family. So, I mean, it felt like a part of my womanhood gone.
Thank you. All right, so now we're going to talk about the usage and history behind hair relaxers. So we know that African hair, Black hair, it's usually very coarse, kinky texture. Even prior to slavery, African hairstyles were status symbols reflecting your marital age, religion, rank in society. Tribe warriors, kings wore braids to show their ranking in society. However, that kinky coarse hair didn't normally meet the European standards of beauty. And instead, a lot of articles, even in the New York Times articles, said that African-American hair was closer to sheep wool than human hair. So that African hair that was once considered an attractive feature now became shame and something that was covered and manipulated in America and around the world. Naturally, Black women, they strive for a better life in America. And so they were taught that the straighter and less kinky their hair was, the better their life could be. And so today, defendants market their hair relaxer products to Black consumers around the country, reinforcing the same historic Eurocentric standards of beauty. Even in that same NBC article, we hear one of our clients talking about how she wore an afro all through college, but after she finished college and she needed to find a job, she went ahead and got a relaxer because she didn't believe that she could get a job without having straight hair. So this is just kind of something for you all to understand why women were relaxing their hair. We can go to the next slide. Hair relaxer marketing is very prevalent. We know there is a lot of marketing for hair relaxers. Black people only make up around 13% of the population, but by one estimate, African-American spending accounts for as much as 22% of the $42 billion a year personal care product markets, suggesting that Black people buy these products more, and that therefore they're more susceptible to using potentially harmful ingredients that are in the product. We can go to the next slide. So these are just some of the defendants right now. There's around over 25 defendants that different plaintiff firms have filed against in the MDL. These are just some of the defendants. There's many more that aren't listed. Each defendant sometimes can seem like it's in its own mini litigation because each defendant has its own defendant team to work through different discovery issues in the MDL. We can go to the next slide. And here is just a list of some of the other defendants. You can see we've got Godridge, Strength of Nature, who are Georgia defendants. Most cases are filed in the MDL, which is in the Northern District of Illinois before Judge Mary Rowland. Right now, there's over 8,500 cases filed in the MDL, but there's also state court litigations going on in at least Georgia and Illinois. Georgia has some state-specific manufacturers such as McBride, who make design essentials. There's also Godridge, Strength of Nature, Bronner Brothers, just to name a few. And there's litigations going on in at least Chatham County and DeKalb County. And Chatham County now has a consolidation order entered. And there was also a motion to dismiss that was denied. There are some issues on appeal right now from that motion to dismiss, mainly dealing with the statute of repose in Georgia, and we do expect to get a ruling on that sometime before the end of June. There's also litigation going on in Illinois. State court, there some typical defendants that are home based there would be Avalon, who makes the Affirm hair relaxer, or AFAM, just to name a few. We can move to the next slide. Right now, there were 8 new defendants who were added to the MDL just within the last couple of months. You can see there's a list here. Some of the more known may be John Paul Mitchell Systems, Bronner Brothers, Murray's, Advanced Beauty Systems. We can move to the next slide. And here's just a picture of some of the products, different hair relaxer products. Next slide. So when we talk about the science, I know you may wonder, how are the hair relaxers linked to uterine cancer? So there was a study that was released by the National Institute of Health in October of 2022 that found women who use chemical hair straightening or relaxing products have a considerably higher risk of contracting uterine cancer. The study found that estimated that only 1.64% of women who never use chemical hair straightening would go on to develop uterine cancer by the age of 70. But for frequent users, that risk more than doubled, increasing to 4.05. And when we talk about frequent use of hair relaxer, we're talking about using it at least 4 times per year. And this was really alarming, particularly for Black women, because the incidence of uterine cancer in Black women is twice that of white women. In addition, Black women with uterine cancer carry a poorer prognosis as compared to white women. Though death rates from other cancers in women have declined in recent years, death rates for uterine cancer has increased by more than 100% in the last 20 years. Also, in another publication from researchers of a sister study, found that the risk of ovarian cancer doubled with frequent use of hair relaxer. And while we know that overall rates of ovarian cancer are slowly declining in the U.S., Black women continue to have the poorest survival rates of all ovarian cancer subtypes. We can move to the next slide. So, endocrine disrupting chemicals. Hair relaxers can, and they often, when applied, will burn the scalp and cause lesions on the scalp, facilitating introduction of hair relaxer chemicals into the body. EDCs disrupt the endocrine system and interfere with the body's hormonal regulation and normal activity of the endocrine system. A slight variation in hormone levels can lead to significant adverse health effects, including reproductive impairment, infertility, cancer, cognitive deficits, and immune disorders, among other things. Natural and synthetic EDCs are present in hair products under the guise of fragrances and perfumes, and they can enter the body when applied to the hair and scalp. Studies exploring issues have classified EDCs as estrogens, phthalates, and parabens. We can move to the next slide. So what exactly is in the hair relaxer? There's many ingredients, as you can see, that are in different hair relaxers. We see phthalates, formaldehyde. One of the main ingredients in a lot of hair relaxers is lye, which is sodium hydroxide. No lye relaxers contain calcium hydroxide, and so no lye relaxers were normally marketed to make consumers believe that they were safer and cause fewer scalp lesions and burns than lye relaxers, but there's really little evidence to support that claim. To the next slide. So phthalates. We know that phthalates are known to cause endocrine disruption, which are not required to be listed separately as ingredients and are often lumped as fragrances and perfume categories. Relaxer habits for Black women usually begin in the early childhood years and adolescence, which is a period of increased susceptibility to debilitating conditions resulting from exposure to chemicals such as phthalates. And we know that hair relaxers contain phthalates, including DEHP, which is a highly toxic manufactured chemical that does not occur naturally in the environment. And so DEHP is considered a phthalate. We can move to the next slide. So DEHP, we know that it's banned in multiple other countries. The European Union has banned the use of phthalates. Canada has banned the use of DEHP in cosmetics since 1994. Other countries have banned DEHP in children's products, countries such as Mexico, Japan, Argentina. So we understand that this is not really new knowledge. And so we can go ahead and talk about the regulations in the US. We can go to the next slide. So we know that the FDA regulates the cosmetics, including hair smoothing products under the Federal Food, Drug, and Cosmetic Act. We can move to the next slide. And so there's two main acts that you can look at that are most important when it concerns cosmetics marketed in the United States, and that's the Federal Food, Drug, and Cosmetic Act, as well as the Fair Packaging and Labeling Act. And so we know that with the Fair Packaging and Labeling Acts, the regulations do not require the listing of the individual fragrance or flavor ingredients, meaning that if you list an ingredient in the in the flavor ingredients or the fragrance, you can sometimes hide certain ingredients. We can move to the next slide. And so we also have the Federal Drug and Cosmetic Act, which expressly prohibits the marketing of adulterated or misbranded cosmetics. We can move to the next slide. And so these are some of the injuries that we are investigating right now. We're actively filing cases for uterine cancer, endometrial cancer, and ovarian cancer. Next slide. And we pretty much have a pretty liberal filing criteria right now. They just need to have been diagnosed with one of those cancers and use the hair relaxer for at least 4 times a year for a period of at least 2 years. They could have had the product applied at a professional salon or at home, but at a minimum, they really need to know which products that they use so we can know which defendants need to be involved in their case. We can move to the next slide. And so discovery is ongoing right now among both sides. There are PFS, the first wave of PFS meet and confer is actually this Friday between all defendants and all plaintiffs. And so that's all I have for right now. If you have any questions, feel free to send me an email. Thank you.
All right. Well, on behalf of all our viewers, I want to thank Ryan, Clinton, and Aigner for a fabulous presentation. I'm always amazed by the work that my partners do, and I really, really enjoy learning from them. So we've covered a lot of ground today. We have received a few questions during your talk. I'd like to take a moment to try and pitch those to you if I can. To the extent we don't have time to cover one of your questions live, we will send you a typed response after today's program. So our first question comes from William, who asks, for the acetaminophen litigation, in light of the MDL judge's expert rulings and the appeal process, what other venues are being considered, and where has Beasley Allen filed? Ryan, do you want to take that one?
Yeah, thank you, William. We have not filed additional cases yet. We are still evaluating our options, and I'm not trying to hide the ball or anything. We really are evaluating our options. One option, I mean, could be Pennsylvania in light of the Supreme Court's Mallory decision. But we're still discussing and coordinating with our other firms on leadership that were in leadership in that MDL to see what's the consensus on best potential other venues. And hopefully the MDL will continue to work out too. But yeah, that's where we are right now.
All right. Our next question comes from Anisha. She asks a hair relaxer question. Aigner, here it is. If a client has a family history of cancer, what are some of the ways you go about ascertaining that the cancer was caused by the hair relaxer usage?
Right now, a family history of cancer is not, we will still accept that case. That's not anything that we wouldn't accept. As far as saying that it's caused by the cancer, there are different reasonings that we can say, basically that there could have been a warning. If they had a family history of cancer, then they really should know that using the hair relaxer on their hair can increase that risk. So that's one of the important things that we would use.
Okay. And then Ryan, I think we've got time for one more question. It comes from Marlon. He asks, with regard to semaglutides, how common are the injuries mentioned? Are physicians reporting seeing an increase in injuries as these drugs become more widely prescribed?
Yes, so it's hard to say in the abstract. There has been this is off the top of my head, don't quote me on it, but I remember seeing that there was at least I believe 10,000 adverse event reports. The FDA has a adverse event reporting database, and I think that we've seen at least 10,000 or so in there. And we are, I mean, from the consensus of, I guess, other firms, we've been seeing quite a bit. It was proposed at the JPML hearing that this litigation would expect to get to the size of about 10,000 lawsuits. We're still very in the early stages of that. I believe around 150 or so have been filed so far. But there's a lot coming. And what's interesting and new about this is that unlike maybe a drug that was recalled or so, this drug is still not only on the market, but it's increasing in popularity and more people are taking it. Even, I mean, Oprah Winfrey specials, all kind of stuff. There's millions of followers on it. And that kind of contributes to the shortages too. But yeah, we expect those type of numbers and for it to continue to grow.
Thank you, Ryan. And that's all we have time for today. But for those of you who may have missed our earlier announcements, by the end of this week, you're going to receive an email with a certificate of attendance and an updated presentation and video link that includes all of the slides you've seen here today. You can email that completed evaluation form to webinars@beasleyallen.com. Again, for those Alabama and Georgia attorneys participating by phone, please don't forget, email us your name, phone number, and state bar ID number. You send that to webinars@beasleyallen.com. That's webinars@beasleyallen.com. That'll help us ensure you receive full CLE credit. Also, be sure to check out the events page of our website, beasleyallen.com/events, as we're going to be adding more webinars throughout the year. We've got a lot of exciting stuff coming for you in the coming months. So thank you for joining us today. Thank you so much again for supporting our Beasley Allen monthly webinar series. Have a great day.